Good afternoon, Jean.
Good afternoon.
Would you please identify yourself?
My name is Jean Dubofsky.
Can you give us your educational background?
Yes, I grew up in Topeka, Kansas and graduated from Topeka High School. Then I went to Stanford University in California and graduated in 1964.
Is that where you met Frank?
Yes. And then I went to Harvard Law School and graduated in 1967.
Can you kind of summarize your career since 1967? Well, take as long as you like.
Well, I first went to Washington and worked for then Senator Walter Mondale from Minnesota for a couple of years. And I was very fortunate. I got to work on the two major issues he worked on during that time. The first was establishing East-West trade. In 1967, the United States didn't trade anything with communist countries, and any computer-related or high-tech items could not be sold anywhere overseas because they might be sent on to communist countries. And some of the big manufacturing companies in Minnesota like 3M and Control Data were very worried that they weren't going to have any international trade and they'd be behind all other countries, or at least U.S. development of world trade in the areas of high tech would just not come about. So this was legislation that changed all of that and allowed trade with communist countries. It was the year before, a couple of years before President Nixon went to China. And the other issue I worked on for him, and I did most of the staff work on it, was what became the Fair Housing Act of 1968. He was the chief supporter of it, and it was filibustered in the Senate. So I got to meet every day with the senators who were involved in trying to get the bill passed, including most of the best-known U.S. senators.
What did the bill provide?
It provided for fair housing for blacks, primarily African Americans in this country. Until then, much of the housing in the United States would not be available for rent or sale to African Americans except in black neighborhoods. So that was a major, major piece of litigation. And it actually passed the House of Representatives. It had already passed the Senate only after Martin Luther King was assassinated. And that's why we have a fair housing law in this country now. I'm not sure we could adopt one if we had to at this point. Then I went from working for Senator Mondale, worked for legal services briefly for the South Florida Migrant Legal Services program that provided legal services for farm workers. And I managed to attract controversy in ways I don't quite understand, but at any rate I did a slavery case, which was the first slavery case brought in the United States in many, many years against the largest landowner in Palm Beach County, who was holding workers from Caribbean islands, young black men, 15, 16 years old, under gunpoint to work on his farms. And the lawsuit was successful, but the landowner disliked legal services so much that he saw to it that most of the program's funding was cut. So Frank and I were both working there. We went back to Washington and then moved to Colorado to work for the Rural Legal Services program here, or at least I worked for the Rural Legal Services program here. I worked there for a couple of years.
Was that in Boulder?
That was in Boulder. I worked with Skip Chase.
What do they do?
They provided civil legal services for farm workers throughout the state. And the office in Boulder provided backup research, did law reform cases, and worked on legislation. And that's what I did. I worked in the Boulder office and did that for a couple of years. And then I went to Denver and worked for the legal aid agency of Metropolitan Denver. And while I was there, I worked primarily on legislative reform. We'd take problems that poor people might have with mobile home park rentals or with food stamps or with any number of government-related programs and go to the legislature. If a case was filed in court, it could also be dealt with by the legislature, and it was pretty successful. One year we got 34 bills passed, and the legislature was controlled by Republicans. So that was one of those legal services programs that was a little too successful too. And
What do you mean
Congress-
too successful?
Well, we got too many remedies for our clients, and so Congress said that federally funded legal services programs could not do any legislative reform. They could not do any class action litigation, and they were to take cases only on a case-by-case basis. So that's what legal services to this day does. And I left Denver Legal Aid after another couple of years and formed a law firm in Denver with a man named Terry Kelly. And that law firm was Kelly, Dubofsky, Haglund, and Garnsey. And then for many years it was Kelly, Haglund, Garnsey, and Kahn. So it's gone through a number of sort of changes, but basically it's still the same people at the same law firm. But I left there to become Deputy Attorney General, which was the number 2 person in the Attorney General's office when J.D. McFarland was elected Attorney General. So I was there for a couple of years and then went back to Kelly Haglund for a while. And from there, in 1979, was appointed to the Colorado Supreme Court. Dick Lamb was governor, and I was the youngest person that had ever been appointed to the court, and the first woman.
How old were you?
I was 37. And
What did you think of that experience? You're no longer on the court.
no, I was there for 8 years. I thought it was very interesting. I think I liked the job more than any of the other people on the court did. It's pretty academic. You spend most of your time reading, writing opinions, and I really liked it a lot. In some respects it was difficult because I think whenever you're the first person appointed, like a first woman or first minority appointed to any particular position, you feel as if you can't make any mistakes, and then you've got to be very careful and just do things in a way that will mean that there'll be other people who get to come after you. And our children were very small then. When I was appointed, Josh was 4 and Matthew was not yet 2. So I had my hands full. I had a lot that I had to accomplish every day.
But you had a Guatemalan nanny.
No, we didn't. We had a woman who started working for us after I began on the court, who was there, 4 or 5 years at least, maybe longer. Boulder's an interesting place for finding childcare, or at least we found it was, because there are a lot of people who are pretty well educated who are looking for jobs, and we never had any trouble finding, childcare, 10 hours a day, 5 days a week, women with college degrees. Sometimes, one summer we had, as a summer part-time babysitter, a boy who was the captain of the football team, the quarterback for the Boulder High football team, pitcher for the baseball team, and played on the basketball team. And we attracted every little boy from blocks around because they too wanted to have him as their babysitter. But most of the time we had We had young women who were college graduates. We were very fortunate in childcare that we had. Anyway, so I left the court in 1987 and taught for a year at the law school at CU.
Did you give us your reasons for leaving the court?
Yes. When I was interviewed by the nominating commission before I was appointed to the Supreme Court, they said, "You're very young, how long do you think you're going to stay?" What they were asking me is, did I intend to spend the rest of my life on the court? And I said, oh, I think about 6 years, because I knew that the average length of stay for a justice on the Colorado Supreme Court at that point was 6 years. And it was interesting, because by the time I had been there for 6 years, the law clerks that I had changed every year, but sitting at my desk and the view from my window didn't change. Those jobs, appellate judging, is a very isolating kind of employment. And I could feel myself when I saw cases that that were similar to cases I'd seen before. I wasn't listening quite as carefully. I'd seen this before, and I knew what I thought about particular issues. So I began to think that what I'd said initially was something I really ought to take seriously. And what made me decide that I had been there long enough was primarily my parents' ill health. They were both ill, seriously ill, and they lived in Topeka, Kansas. And it's hard to get there, and it was very hard to deal with. So I had to deal with that. And both the kids were getting to an age where babysitting didn't work as well, because they didn't do everything their babysitter might tell them to do every day. And I thought it was more important that I have a little more time at home. So I left for a whole combination of reasons after 8 years, and went. Well, I taught for a year, and then I started practicing law again, and built up what has been primarily an appellate practice. And I've been doing that now since 1988. So I've been doing that for the last 20 years. And I've had wonderful cases. I've had the best law practice of anybody I know. I just don't think you can put together a variety of the types of cases that I've had. I've done criminal cases and domestic relations cases and commercial cases and civil rights cases and personal injury cases, and just about any kind of case, mostly in the appellate courts. And I still find it fascinating. I'm getting to the point where I don't want to work so hard. It's pretty hard work, but I've loved it.
You're well known for your work on Amendment 2.
Yes.
We'd like to hear you talk about that. In a preview of that, you might explain how the appellate process works.
Okay. Once a case has been tried and there's a final judgment, the party who didn't win can file an appeal. And in Colorado, you go first to the State Court of Appeals, and then if you don't like the result in the State Court of Appeals, you can go on to the State Supreme Court. If you're in federal court, you go from the Federal District Court to the 10th Circuit U.S. Court of Appeals to the U.S. Supreme Court. And the cases are decided based on the record, the transcript of the trial, and that's it. Judges are not supposed to, on appeal, take into account anything else other than the evidence that was put before the trial court. And the appeal is basically whether the law was correctly applied to the facts that were established in the trial court. And an appeal will be resolved with a written opinion, some of them published in the Court of Appeals, all of them published in the State Supreme Court, and all of them published in the 10th Circuit U.S. Court of Appeals. And those published decisions provide guidance as to what the law is for cases that come after the decision in these particular cases. So, for example, the Colorado Supreme Court chooses the types of cases it takes. And it chooses them frequently based on whether this particular case will make law that can then govern cases that follow. And the law changes incrementally over time. It's based on the old common law system. We don't have that anymore, but we almost have what you could call a common law of statutory interpretation. We do have some areas of common law, but most of the law is enacted by the legislature or by Congress. And the courts then interpret that law, because even though the legislature may think it's coming up with laws that will govern every situation, something always happens that no one anticipated, and so that the courts fill in the ways in which the law is applied. And then, of course, there's some laws that are much more general, and it's expected that the courts will ultimately determine the ways in which those particular laws are applied. So that's what an appellate court does.
Okay, good. Thank you for that. Now take us to Amendment 2.
Okay. Amendment 2 was adopted by the voters in Colorado in 1992. It is basically, or was, an anti-gay rights initiative that was adopted by about 53% of the voters. It arose in California a few years before it came to Colorado. It came to Colorado because many of the people who came to Colorado Springs to work in a 57-acre business development for religious organizations came from Southern California. And so in the space of a few years, they had been working on some anti-gay rights initiatives. At the trial we had on the case, we put on evidence that explained that these various, mostly far-right religious groups had begun an anti-gay rights effort after communism basically went away, which was in the late 1980s. And they lost anti-communism as a means of raising money. And anti-abortion efforts weren't as effective because the percentage of the population that favored a woman's right to choose had increased to substantially more than 50%. So they were really looking for some new way of raising money, and it's about as cynical as that. The AIDS crisis came along, and lo and behold, gay men particularly, and then lesbians, but gay men particularly, became the target of these religious organizations, and they were pretty successful. They went, well, Colorado had almost no law that protected gay men and lesbians from discrimination on the basis of sexual orientation. But the religious organization said that there was a gay rights agenda and that it needed to be blocked in Colorado. The only laws that ultimately were blocked by this were anti-discrimination in employment and public accommodations in Denver, Boulder, and Aspen. There were no state laws. The only state policy that had been adopted was a provision of the insurance code which said that insurers could not discriminate in the provision of health insurance based on zip codes. And that was a provision of law that was adopted after gay men living on Capitol Hill could not get health insurance because insurers didn't want to pay for AIDS. So what they did was say that any male who was single who lived in that particular Capitol Hill zip code could not buy health insurance. And then other than that, there were some police policies in Denver, and there were a few university anti-discrimination policies, but that was it. Colorado had not seen a lot of gay rights activity at all. It was no San Francisco and no New York City in terms of having large gay populations. The initiative, when it was proposed, most people thought it wasn't going to go anywhere. The polling showed that it was not going to pass. But the election in 1992, when Bill Clinton was first elected president, had Ross Perot on the ballot. And Perot got 25% of the vote in Colorado, the second largest percentage after Texas in the country. And because he was on the ballot, he brought out a lot of people who did not customarily vote, a lot of libertarians or people who were anti-government in general. So the polling turned out not to have been very accurate because the pollsters only looked to people who were likely to vote or who voted in the past. And Amendment 2, as well as TABOR, the Taxpayers' Bill of Rights, which was not considered to be something that was going to pass, both of those initiatives were adopted in Colorado. Polling after both of them were adopted really showed that you weren't ever going to get either one of them repealed by the voters. So I had been asked, 3 or 4 months before the election, if I would take on a lawsuit to challenge Amendment 2 if it passed. And I didn't think it was going to pass, and without thinking very much about it, said, oh, sure, of course I will. And so I worked pretty hard for the next few months so that we had a lawsuit ready to go with plaintiffs who were gay men or lesbians. We also had the Boulder Valley School District, the cities of Denver, Boulder, and Aspen ready as plaintiffs, and we made a lot of different challenges to the amendment. I should explain what that amendment did, because it was breathtaking in its sweep. It said that at any level of government, so you went from the most local level all the way up through state government, any branch of government, so it included the courts as well as the executive branch and the legislature, could not adopt any legislation or ordinance or policy that would provide protection against discrimination on the basis of homosexual orientation. What it basically did is said that gay people have no rights whatsoever in Colorado, and anyone who tries to protect any government agency or activity that is intended to protect them can't be. Amendment 2 trumps. People who looked at it in terms of advising this, a lot of law professors were just mystified about what to do about it, because it really took one class of people and took away any kind of rights they'd had or might have in the future. It said that you couldn't, it repealed all the old protections, which were pretty limited, and then said, and you can't have anything in the future that will provide any kind of protection. So, to make a long story short, we went to the district court in Denver, filed an injunction action seeking to get it enjoined before it officially went into effect in mid-January of 2003.
Now you're active at the trial court level.
Yes, I was lead counsel from the very beginning, put together the plaintiffs and the complaint, and I had turned out to be a cast of thousands. We laughed about it because I've never had so many volunteers for anything in my entire life. All over the country, people were calling, what can we do to help? I mean, the most famous constitutional law professors in the country all wanted to help because nobody had ever seen anything quite like this. And to figure out a theory to hold it unconstitutional under the U.S. Constitution was really difficult, because the only case that the U.S. Supreme Court had decided on gay rights issues was one called Bowers versus Hardwick, which was a case that said that people could be prosecuted for sodomy, sodomy that was engaged in their private homes. It could be a crime, and the U.S. Supreme Court had upheld that. So the court was viewed as really very hostile to any gay rights cases, and there had been a series of cases around the country that had all used the language from Bowers versus Hardwick, which was disparaging, awful language. I mean, it was sort of, people would say things about gay people that were exactly the same things that had been said about African Americans before the civil rights era began in the 1960s. I mean, it was just, they gave people all kinds of diseases, and what they did was unnatural, and it just went on and on and on. And the language in those court decisions was such that it felt as if a court would never give a plaintiff in a case any kind of relief. So we had to figure out a way to make a claim that would allow us to win our case and yet not make the Supreme Court have to, let's say, declare sexual orientation a suspect classification entitled to the highest degree of protection under the law of equal protection. Our main claims were equal protection claims under the 14th Amendment, but we framed them in a way that the court ultimately bought, and that was, there's not even any rational basis for something that sweeps as broadly as Amendment 2, that it was motivated only by impermissible bias against gay men and lesbians. And what was extremely helpful was that the groups that supported Amendment 2 had done a newsprint broadside, an 8 pages, newspaper stock brochure that they'd put on every doorstep in the state, either the night before the election or 2 nights before the election. And the language in it is just horrific. I mean, it's the same kind of bigoted references that I was talking about. And so by the time we got to the U.S. Supreme Court with this case, that little brochure was in its own little plastic pocket that was part of the briefs, not just sitting down in the record somewhere, because I thought that proved that this was impermissible bias. That's the way the amendment was sold. Well, there were all kinds of legal barriers to bringing a lawsuit that is aimed to declare a statute unconstitutional, or a state constitutional amendment, which is what Amendment 2 was, unconstitutional before it goes into effect. The courts don't like to take things like that, and so it's very often you can't even get to first base until someone is discriminated against under the statute. We didn't want to take on Amendment 2 on a case-by-case-by-case basis, because it swept so broadly it would take a generation to get all the various problems with it hopefully taken care of. We wanted to stop it before it went into effect, and we also didn't want to see it adopted anywhere else. And there was a major effort by all the various religious groups that were related to the groups that had pushed Amendment 2 to get it on the ballot in most of the other states that have provisions for citizen initiatives. So we felt it was really important to get it stopped right away. The news media loved the case. We had our preliminary injunction hearing was broadcast live on Court TV. We won a preliminary injunction, went to the state Supreme Court, or the state went to the state Supreme Court immediately, and the state Supreme Court upheld the preliminary injunction. Then we went back to trial court for 3 weeks of trial.
And you're in the federal district court.
No, we're in state district court. We went to state district court because I wanted to be in the state court system. I thought the judges in the state court system who had to live with Amendment 2 would be more likely to overturn it. If you recall, Colorado had been labeled the hate state, and all the conventions that came into Denver were being canceled, and there was just this whole sort of negative sense that how in the world can this state do something like this? And I think most judges in the state probably would not have voted for it. So I thought we'd be much better off with a Denver district court judge who had to file suit in Denver if you're suing the state. And you can only sue the state to declare a constitutional amendment unconstitutional. So the defendant in the case had to be Roy Romer, who was then governor, who had been co-chair of the group that opposed Amendment 2. But he thought he could not confess that it was unconstitutional, that he had an obligation to uphold it once the voters put it into the state constitution. Gail Norton was the Attorney General, and people in her office was pretty split on what they thought about it, but they fought the case pretty hard. It was interesting because their first defense of the amendment was that it wasn't going to have any impact. It was like declaring English the official language of Colorado. We have that in our state constitution also, in an effort to, I don't know, put down Hispanics. But at any rate, they said, oh, this is just sort of something that says, well, we don't like these people, but it's not going to really have any impact. Well, that was the way they framed their preliminary injunction defense. And if they'd stuck with that, I think Amendment 2 would still be part of the state constitution. But after the state lost the preliminary injunction, the people who had supported Amendment 2 in the first place said, we don't like the way you're defending this. We are going to intervene in this case unless you put on all this evidence about how bad homosexuals are and all that sort of thing. So the state switched strategy to keep that group from intervening and defended the amendment, basically conceding that it would have a major impact on people. And the case proceeded. You know, we had 4 weeks of trial about it, and the Supreme Court upheld it after the preliminary injunction. After the next 3 weeks of trial, it went back to the state Supreme Court. State Supreme Court upheld the district court ruling again. So at that point, Amendment 2 had been declared unconstitutional. But the U.S. Supreme Court then took the case. The state had asked the U.S. Supreme Court to take it after the preliminary injunction affirmance. Court didn't, but it did take it after the final judgment by the state Supreme Court, and my heart sank when they took it. I thought, oh, we got rid of this. But the governor was just insistent that he needed to defend it all the way, and seemed to think that, oh, this is going to be easy. And I ran into him somewhere and said, it's not going to be easy. We'll just have to see what the Supreme Court does, but I'm not sure where we get our votes on the Supreme Court to uphold what the state Supreme Court has done. At any rate, we briefed the case in the U.S. Supreme Court, and there were amicus briefs filed from all over the country in the case. We had a lot of help from good lawyers around the country who prepared amicus briefs. I had a young man who'd sort of shown up on my doorstep looking for a job, whom I still think was a gift of some sort to me. His wife had gotten a history position at CU. She was the only PhD in history from Yale who got a job out of that program that year. So they had to come here because she had no employment opportunities. He had a law degree from Yale, and he's the brightest person I've ever met in my life. His name is Rick Hills. He's now a law professor at NYU, but his parents are well-known Republicans and Republican government officials. At any rate, he put together for me just some incredible work on this case. He started out after college going to get a PhD in philosophy at the University of Chicago. The state had all of these witnesses who were philosophers. We went back to Homer and the Greeks and all of that. And he knew every philosopher that you ever needed to contact to counter all of this. I mean, this case was just incredible. And I didn't know all of that. Plus, I had so much to do in terms of just managing all of the people who were involved in the case that I could never have managed to do this without his help. So he worked with me through the, actually he helped with the U.S. Supreme Court briefs, but by then he'd gone to teach at the University of Michigan Law School. So I was very fortunate. But anyway, we just had thousands of people that felt like working on this case or interested in the case. The Supreme Court had more requests for passes to get into that argument than they'd ever had for any case in the court's history. The courtroom was just jam-packed for the argument. And it was absolutely, for me, certainly the highlight of my legal career. It was, arguing that case was very worrisome, and finally...
Who presented the argument?
I did.
Oh, you did.
And Tim Timkovich represented the state. He's now a judge on the 10th Circuit in Denver, but he went first because they'd lost in the state Supreme Court, and the first question to him was from Justice Kennedy, who said, "I've never seen a law as bad as this." That was his first statement. And the whole courtroom let out an enormous sigh, kind of, "Oh!" gasp, because he was the fifth vote. And in the U.S. Supreme Court, what you need to do to be successful is know how to count votes. So you have to know where your 5 votes are coming from, because there are 9 justices. And he and Sandra Day O'Connor were our 2 possible swing votes. And he tipped his hand on the very first question. So I relaxed at that point and thought, okay, this is going to be better than I thought it was. And indeed, it went pretty easily. Justice Scalia made life miserable for anybody coming before the court. But he had so already signaled what his views were on the case that I didn't have to be as deferential to him as I normally would have been. I could give him some pretty sharp answers. He'd actually come out to CU Law School about 3 weeks before the argument and announced what his view was on the case. So I just figured that I wasn't going to persuade him of anything. I really wanted to persuade his more moderate Republican colleagues, and I didn't have to let him bully me. So, all right.
How long did you have to wait for the decision?
Argued the case in October, and the decision was near the end of the term. The decision was on May 20th, 1996. So I spent almost 4 years working pretty much exclusively on that case.
What was your reaction?
You get this call, and the clerk of the U.S. Supreme Court calls at 8 a.m. on a Monday morning, and so, after a few months, you start making sure you're in the office at 8 a.m. on Monday mornings, because you'll get the first call. And called and said, basically, today the U.S. Supreme Court affirmed the decision in Romer versus Evans. Well, that meant we'd won. And I just gasped. I couldn't believe it. And then the phone starts ringing and all the reporters start calling. And I hadn't read the opinion, so I had to get a copy of it to read it. And the feeling from reading that decision, we won overwhelmingly. The decision was written by Justice Kennedy, and it said, basically there's never been a law as bad as this, that it sweeps too broadly and it targets a narrow group and reflects impermissible bias, and there's no rational basis for it, which was the argument that we'd started out making at the very beginning in the trial court. And that was the argument that he bought. The most important impact of that decision, I think, is that it changed the dialogue in the court system in particular, but in general the public at large, about gay rights issues. You don't see any of that hateful language that used to appear in court decisions about gay rights issues anymore. It's changed incredibly. And that decision really reflected it. And then 3 years later, the court overruled Bowers versus Hardwick. I'd been asked if the court had to overrule Bowers to rule in favor of us in the case, and I'd said no, because technically they didn't. And I figured you don't bite off more than you need in order to win a case. But, so I came away with that feeling like I was so incredibly lucky. I mean, most lawyers never get a chance to do a case like that. And I was pretty frightened all the way through it, but when the U.S. Supreme Court granted cert, I went to Washington to talk with a lot of experienced U.S. Supreme Court advocates, because I'd never been to the U.S. Supreme Court before, about whether we should get someone in Washington who does this all the time to argue the case. And there were all kinds of people who wanted to argue the case. I mean, Larry Tribe, the constitutional law professor at Harvard, really wanted to argue the case. But for a variety of reasons, we couldn't have him do it, because he'd already announced a particular view of certain case law that we had to rely on. And I met with John Roberts, who's now the Chief Justice of the U.S. Supreme Court, because everyone said, well, he's the most successful appellate advocate in the U.S. Supreme Court. You've got to go talk with him. And he told me two things. He says, first, you've got to be able to count. You've got to know where your votes are coming from and tailor your argument to that. And I would have figured that one out. The more important thing he told me was that the court is really only interested in the interpretation of Amendment 2 that the Colorado Supreme Court gave to it. And that it probably made sense if the state was not going to hire one of the Washington people, which they didn't, for me to argue the case, because I'd be in a better position to answer questions about what had happened in the state court system. I didn't need to be an expert on constitutional law. They or their law clerks could supply that. And my favorite moment in the oral argument was when Justice Scalia asked me where in the big book that you supply along with your briefs that has all the court rulings in it. And ours, because we'd had so many court rulings, was about 3 inches thick. Where was what I had just said the Supreme Court ruled? What page? Well, for years when I argued cases, I'd write down on the margin the page number something important was on. Never been asked about it. Get to the U.S. Supreme Court, what's the question? So I had written it down in the margin. I could tell him it was D45 or whatever it was. And so everybody on the bench dutifully opens their little books to look. And so he starts reading a sentence. And I could say, no, it's not that sentence. It's the one above that begins, at a minimum, Amendment 2 means. And he was furious. He slammed his book shut and hurled it at the little thing that goes right in front of him. But that's one of those little things that you think, oh, how could I be so lucky? Anyway, I felt like I was so fortunate, both to have had an opportunity to participate in an important civil rights case, but also to meet and work with the incredible number of people that I got to work with on that case. It was, I mean, one would never have thought that Colorado would sort of become the epicenter of gay rights issues, but it was for a while.
Thank you so much for sharing this
You're
with us.
welcome. It goes on and on, doesn't it?
It's wonderful that it does.